Welcome to Law Help Australia, where we keep you safe and informed with tips and updates. My name is Dinesh Weerakkody. Have you ever been to a criminal trial, either in the Supreme Court or in the Magistrates Court? Do you want to know the questioning style, the court etiquette? Let's find out now. But before we do that, let me introduce you to the panel today. Harlis, can you tell us a little bit about yourself, please?
Sure. My name is Harlis Kirimof. I have two roles. One is as a barrister, which is a kind of lawyer. It's the kind of lawyer that really deals with disputes and appears in court. And my other role is as a lecturer, so I lecture at Deakin University.
That's a good university, by the way.
It is.
And Chen?
Yes, hi. My name's Chen Yang. I'm a principal of Vale Criminal Law. We specialised in criminal law and traffic law. I've been practicing for about 4 years and I'm a solicitor.
And Emily?
Thanks, Dinesh. I'm a lawyer at DLegal. We're practicing mainly in criminal, family, property and conveyancing matters and traffic law as well.
All right, okay. So let's talk about the examination in a criminal trial process. So we've got the examination in chief and cross-examinations. So what's the difference?
Well, Dinesh, the examination in chief is when you call your own witnesses and you ask your own witnesses questions. And the evidence you elicit from that witness is what we call evidence in chief. So it's when you ask questions of your own witnesses. That's the examination in chief.
Basically, a witness is trying to tell their story in their own way.
That's correct.
All right. So what's the cross-examination then?
Well, Dinesh, cross-examination is mainly to bring out very skillfully all that the witness omitted to say, what they suppressed in examination in chief, if they slurred any of their evidence in their speech, and also what they may have deliberately lied about, although they really shouldn't be if they're in the witness box because they would have taken an oath or done an affirmation, or to suggest that the witness is unreliable or dishonest.
So let's start examination in chief. Where do we start?
Well, it technically, and from I suppose the jury's point of view, it starts when you ask your first question of your own witness in the courtroom. Of course, the reality as lawyers is that you should have already prepared or understood exactly what your witness is going to say, so there would have been a lot of preparation beforehand to say, all right, well, what is your story? What did you do? And you'll probably, in the process, prepare a statement, or what some people call a proof, of what your witness saw.
So as a defense lawyer, so where would you start? How would you start?
Dinesh, we usually start big. We think about the big picture. It starts from the very first meeting. We take to very detailed file notes. We listen to the background of how these allegations came into being. We will ask our client certain questions in the style that we may during examination in chief and cross-examination, all in order to basically preempt what other parties involved in the trial will be thinking.
And Dinesh, what we try to do is we try to have a strategy. We try to form a plan, a way to tackle this case. And I think what the way you elicit the evidence from your witness is very important in that how it fits into the plan. They need to know exactly what they're saying. They need to tell their story so it's believable and it's the truth. So that's one of the most important things that we would ensure in an examination.
Including the considerations for the line of questioning, yeah?
Definitely.
We have to use our skills, experience in similar matters and in our professional training in order to do all of those things as well. So.
It is a fundamental rule of advocacy that each question must have an objective, isn't it? You just don't ask a question for the sake of it or just because you run out of questions. Let's do a role play to make a point clear. So, Chen, what did you see?
Saw a glass of water and some paper, Dinesh.
Anything else?
I don't think so.
Instead of that line of questioning, we could take another angle and let's start. Did someone else arrive?
Yes.
Who was that?
Captain Jack Sparrow.
Did he take some items into his possession?
Yes.
Do you remember any particular item which attracted his attention?
Oh yes, there is a gun and a bottle of rum on the table. I forgot about that.
Right. So, the skills, experience and judgment of your advocate is quite important. You see, in the second line of questioning, he wanted to get certain things out, like the bottle and the gun. In the first instance, because of the line of questioning, it was not mentioned. So that's why the second line of questioning was adopted. This example shows that the main objective of the line of questioning is quite important.
Dinesh, this kind of all fits into the development of the theory of the case. So as you said, it falls in line, I guess, with that objective too.
Explain a little bit more. What's developing a theory? What is a theory?
Advocacy teachers always talk about case theory. And what a case theory is it's essentially your side of the story or what you say happened. Because the evidence will only show certain parts of the story, and you have to fill in the gaps by presenting a plausible explanation of what happened. And so when you have a case theory, what you're doing is you're essentially picking a theory about what actually happened that is consistent with the evidence. And there might be several different things that are open. If, for example, you're accused of having murdered someone, your case theory can't be that you're innocent both because you weren't there and because you were acting in self-defense. It has to be one or the other. And so, although the evidence might only show parts of the story, you have to go into the courtroom with a clear understanding of what your story is. And that's essentially what a case theory is.
Thank you for that.